Hi, everyone. Today's Friday. I normally don't do lives on Fridays. It's usually a Thursday noon thing. But yesterday, I was in Mexico helping a client come in, so we had to postpone the live to today. Today's live session is a big one. We're talking about visa waivers getting detained by ICE. Okay? I mean, this is pretty insane. Last week's live, we talked about how a green card holder who came into the country got stopped by customs and got detained by ICE and still is detained by ICE. But that's last week's story. Today's story is about people who are on ESTA, who got married to a U.S. citizen, who came in through a visa waiver, who applied for a green card, who got denied, detained by ICE, and their bond got denied. Absolutely insane. We're going to talk about that in the news segment. Then we'll be answering questions as usual, so feel free to ask any and all of your questions regarding immigration. I'll do my best to try to answer everything. And then we'll do the success story, which is about our request to terminate a deportation proceeding that got approved. It's amazing, it's great, and they all tie together. It wasn't planned this way, but it works. And so we're really focusing on detention, deportation. We're talking about the policy changes with USCIS, with ICE, with bails, and with deportation. So it's a lot of stuff that we're going through today. Feel free to ask questions. I want to get into it. I'm going to immediately start with the main news for today, which is the fact that if you came in as a visa waiver, if you came in as with your ESTA, and then now you are doing an adjustment status because you have a U.S. citizen that's petitioning you, whether it's your spouse, your parents, your children, or, you are in the process of adjustment of status. If the case gets denied by USCIS for whatever reason, and then now you are detained by ICE, you're not even allowed to get bond. And that is a breaking news. First, I just want to rewind back just even a few months ago. It would be impossible, it would be improbable, it is implausible where somebody who's going through the adjustment of status process, where you're married to a U.S. citizen, if the case gets denied, where after the case gets denied, you would receive a notice of intent to appear to go to immigration court. That by itself was already almost unheard of. Sure, the policy has been on the books since I think 2019 or so, where they wanted to say every time USCIS denies a case, they will give you NTA, but it just hasn't been the practice. Very few people got it. If your case got denied for paperwork reason, wrong check, wrong mail, wrong signature, failure to provide sufficient documents, just go around, pay the filing fee, and file again, a second adjustment of status. That has been the norm up to a few months ago, where now, sorry, your case gets denied, you get a notice of intent to appear, now you have to go to immigration court. And then, not only are people getting NTAs, now you have to do directly a check-in with ICE, even before you go to court. Okay, that is extremely strange. So it went from not being able to file again to deportation, to having a check-in with ICE, and then last year around, I want to say October, midway through October of last year, suddenly people got detained during the marriage interviews by ICE for a few hours, for a few days. Again, unprecedented, unheard of, impossible. It happened, spreads panic throughout the country. We reported it. I was there when it happened. That was insane. Then you cannot get bond. Okay, that was really crazy. And just this week, what we saw was somebody who came in as a visa waiver, married to a U.S. citizen. Case got denied in front of immigration judge, pleaded for a bond hearing to be able to let out, to be able to to join the family again, and then to fight through the rest of the immigration case. The bond was denied. That is a new low. That is a new low. And the reason why it's such a new low is not because they say it was a case-by-case basis. They didn't say it was, oh, this individual is a national security threat. They said, you came in as a visa waiver. By definition, you signed away your rights to any immigration rights, including bond hearings. I want you to pause to think about that. Visa waiver privileges is given to the best partnering countries of the United States, Canada, the United Kingdom. In this case, it was an individual from Ireland, okay? Visa waiver is given privileges to other Western European countries, to Singapore, to Japan, right? So all the crazy good allies of the United States Foreign Services essentially said, as a State Department, you know what? You don't need to apply for a visa. Just come in, enjoy yourself. All right? We're going to waive the visa. Just come in as an ESTA holder. But now you're in a situation with, okay, you come in, you get married to a U.S. citizen, you file for adjustment. Oh, because you came in as ESTA, we're going to deny you and we're going to jail you for 6 months, and you waived your right to any sort of appeal. What the hell? We're looking into it, and this is like signing up for Disney Plus, and you signed away a waiver, and that means you're going to waive all liability to Disney if you get crushed by a Disney cruise, right? Or anything Disney related. Mickey Mouse comes and stabs you, you waive the right just because you signed up for Disney Plus, right? That just fundamentally goes against the spirit of the visa waiver process. And so what we're seeing now is that a lot of people who are on ESTA are choosing not to do adjustment of status. We've already alerted all of our clients who are in the process, who are thinking about adjusting status. In every way they were able to do it in the past, but because of this case that happened, everybody is reconsidering. It is painful.
Yeah, so they overstayed on their ESTA and were detained without bond.
Yeah. So this Irish individual came in a long, long time ago, got married to a U.S. citizen, filed the case, and now got detained. And now the courts are saying, because you waived your right, you do not have the right to get bond. I think that's messed up. I think that is really putting a scare around the whole world. I don't think it is right. I think that is not the intent of Congress, when they created the visa waiver rules, when they created the adjustment 245A adjustment of status rules, where if somebody entered the country, they can file for adjustment. And I don't think that is what the memos for sending people to immigration court, if their paper application is denied. I don't think that's the spirit of those memos either. So taken as a whole, now you're faced with this unfortunate circumstance where people coming from the best countries, supposedly, who are having some of the best cases, marriage-based cases, and now are in a situation where they could potentially be detained for, months and months without bail. I just don't think that's right. I don't think that's just. I don't think that's humane. I don't think that it's a good public policy. But that is where this administration, different agencies, and their many rules have led to. And it's causing a lot of people from these countries to say, okay, well, then I'm just going to do my immigration process abroad. And you might say, well, then that's great. That's how it should have been done this entire time. But the problem is the immigration system is so broken that this way, using a visa waiver, coming in, and then getting married, and then being able to file adjustment status, this quote-unquote shortcut is already so long, so archaic, so broken, and with so much safety net that's already built in already, that's already a big chore. And if you take this away, the original process and how swamped consulates are, it's going to be even longer, right? So you're breaking a system that's already broken. And the one, simple shortcut that makes it a little bit better, now you're completely trashing that as well without notice, by the way, right? This isn't something like USCIS and ICE announced to the whole world, right? Like Real ID, you announce it back in like 2004, and then you implement it 10 years later. This was like no warning, no notice. The individual gets picked up and puts in detention. Like, the rules are changed in hindsight. That's terrible.
It's interesting, right? Because it was part of the law initially, but it just was never done.
Yeah, visa waiver, you waive your immigrant rights. Okay, that's what they signed up for, right? So just imagine, when you sign up for Disney Plus, you sign a waiver, and let's say you waive the right to contest like a price hike or something like that, right? And then suddenly your Disney annual pass like triples in price on hindsight, and now you have a back pay of 5 years. Like, what? Right? Like, it seems so unjust. Sure, by the letter of the law, you signed this waiver for this one small minor thing that you did maybe 5-10 years ago, right? When people first applied for visa waiver, it was a long time ago. And this individual entered in 2009. Maybe he signed the waiver in 2007. And now in 2026, he's detained by ICE and put in jail, I mean, this whole thing would have been a different story if the court said, no, this is a national security threat. This is an individual case-by-case basis. But by the way the court ruled, now this applies as a precedent to all visa waivers across the country, so it just seems insane and unright. I'm going to take some questions.
So I'm married to an abusive U.S. citizen. I'm preparing for my VAWA case. After I saw its safety, she petitioned divorce. Will that affect my case? And should I file it ASAP for protection?
Yes, VAWA, you can file whether you're in the marriage or it's already divorced. So your right is still protected. A lot of times I get these questions where they said, oh no, the U.S. citizen is going to write something derogatory against me. Oh no, they're filing divorce. They're doing something. And they are trying to blackmail me to stay or to change my behavior. What should I do? And there's a lot of discussion analysis on this. Here's my take. Okay, I'm not going to say I'm 100% right, but here's my take. Any of the actions that they do that is blatantly immoral, heated, passionate, it helps you. Why? Because it shows that the marriage is real, for one, that they're trying to keep you, and it's not a fraudulent marriage, which is a very big part of any VAWA applications. Because even though on paper it is saying you're just being abused, but the underlying idea is that was this a real marriage in the first place, right? And so if it gives you credibility, if they do anything that antagonizes you, document it and use it in your favor. Second, efforts to actually blackmail you, bribing you, threatening you, that only helps your case even more psychological harm and damage. So in this situation, if you've already been abused and then they are doing certain actions, just document it well, and when your case is ready, file. When should you file? When you feel like filing. I mean, if the case is weak, but you just can't wait anymore, file it and make the case stronger. And then when you get a request for evidence, then file more. If you're okay right now, right, physically safe, emotionally safe, you're just gathering documents, and within a month you'll be able to gather a lot more documents, then just wait a month, right? But whatever you do, don't be purely going off of pure emotions. Think through everything. Have somebody by your side, answering, telling you, guiding you. Not necessarily an attorney, right? I'm just saying, like, there are a lot of good counselors out there. Protect yourself. Prepare the case. And I hope you win.
So I'm a Canadian citizen and an LPR in the U.S. I have applied for reentry permit, did biometrics, and departed the U.S. to finish university in Canada. They have the receipt notice in hand, and they cross the U.S.-Canada border very frequently, studying in Canada. They have Nexus, global entry. They're also born in one of the 39 countries with a total exit ban. So my reentry permit is on pause. Are you with me so far?
Okay.
So even if it wasn't on pause, it takes 16 months to process.
Right.
So can they still leave in reentry? It's not the entry ban, but the pending reentry permit is now invalid because it's completely entry banned?
No. So let me slow down and explain. As a green card holder, when you enter the United States, you are just like a U.S. citizen, and you do not need to be inspected or admitted by a customs officer unless some of these qualifications apply to you. I think this is the law 1101. You could kind of look it up. So as a green card holder, you're not admitted. You don't need to be inspected. You just walk in. Unless one of these things happen. One, you have criminal records. Okay, fair enough. National security threat, public safety threat. Okay, they're going to stop you and inspect you, right? Second, you've abandoned your green card. Okay, that's fair. You already signed the 407. You've already abandoned it. You've already left the U.S. for an extremely long time, and you verbally said you abandoned it. Whatever the case, you've already abandoned it. Then they don't have to, quote unquote, let you in. They can inspect you. Third, you've left for over 180 days. So this is the part where it gets a little bit tricky. If somebody leaves the U.S. for 179 days, comes back, stays 1 day, leaves, 179 days, comes back, stays 1 day, leaves, does that 5 years, 6 years, 7 years in a row, officer asks, hey, where do you work? Where do you live? Where's your health insurance? Where's your retirement? Everything is abroad. There's nothing in the U.S. They just come in, buy milk, go back, To the officer, you've abandoned your green card. Okay? So the 180 days and the abandonment kind of goes hand in hand, but the whole idea is that you just need to explain to the officer, I did not abandon my residency in the United States. U.S. is my home. I am abroad temporarily for a limited reason, and I will be back. So given that as your understanding of how the U.S. immigration law works for green card holders who travel in and out of the country, how do you prove your case? I'm abroad, I'm studying, it's temporary in nature. Once I graduate, I'll be here. I have internships lined up. I have, companies here that wants to hire me. I have friends here, I have family here. I'm coming back and forth. I have bank accounts here, I have credit cards. I still have my Netflix account. I have a library card. Do your best to make the argument, I'm not abandoning the U.S. By the very nature, I applied for a reentry permit, and I've proven that I want to get it. It's just because this executive order, but still, my intent, my payment, money talks. This is what I did. So if you're able to do all of that with a good officer, you should be able to come in. With a bad officer, well, you have bad luck and you just have to fight through it, right? But at least that is the basis of your argument. So hopefully that gives you a context to your frustration and confusion. But once you think that through, I think you're good.
How long does it take to get an interview scheduled after applying for N400?
We see anywhere between 3 months to 9 months.
Have you ever had an LPR who was denied admission and got sent back to their home country because of an absence over 1 year?
Oh, absolutely. And what's way worse was the case we talked about last week. A 72-year-old grandmother who came in with 2 U.S. citizen children got detained. And so CBP, customs officer from Seattle, detained her for 2 days at the airport, right? And then transferred to ICE, and then ICE detains her for another 2 weeks, still detained till this second. And when applying for a bond, would not let her leave. That is absolutely insane. And that's the most severe I've ever seen. Almost every other case we've seen is, here's an NTA, you have immigration court, fight it out with the judge, or just go back, voluntary departure, try to come back another day, right? Or, sign the 407 and then come in, right? And so there's all those situations, but this one last week, by far the craziest.
Will green card holders have any issues if they travel abroad?
Don't commit crimes. Don't get on the Interpol FBI wanted list. Come back ASAP, right? Don't stay for over 180 days. If you are, have a reentry permit and be able to explain.
So if the LPR is turned away or they're not allowed to enter, can't they fight that in court? Don't they have that right?
So if you're given, if the customs officer confiscates your green card and they said, I think you've abandoned your green card, here's a notice of intent to appear, fight it out in court, then come in, stay, and fight it out in court. But this grandmother wasn't even given that opportunity. She wasn't even granted bond. She's just directly taken to detention, just like any criminal, just like anybody who's undocumented, who crossed the border illegally. This grandma had a green card for, I think, almost 10 years.
And because ICE can make those proceedings themselves, right? They don't have to go to immigration court, or like they have their own courts.
Right. So ICE takes her, and ICE is detaining her, and then they are scheduling with the immigration court for the bond hearing. ICE does have the privilege to issue ICE bonds to let you leave, so based on their discretion, but they, in this instance, wasn't willing to do that, which is a big WTF moment, and then they have to wait for the hearing. And if the hearing denies the bond, I will be extremely livid.
Even if it's a minor, this could happen?
It happened to a 72-year-old. It could totally happen to a minor.
How long will the 75-country pause last? Do you have any prediction?
Yeah, my prediction is 3 years until this administration leaves. Next administration may or may not reverse it, continue it, but I don't foresee the 75-country ban lifting anytime soon, and I predict it will actually expand to other countries as well.
Do you have any experience with a deportation judge and individual hearing? They changed my hearing from 2026 to 2029.
Oh, shoot. I haven't seen a case pushed back that far unless it's like an asylum case. We don't normally do individual hearings or master hearings or deportation, but today's case is a case that we just did and we succeeded. So I'm going to jump into that and I'll share exactly what we did. Maybe it'll help you, maybe it won't, but at least I'll share what we did.
My brother's case, which was granted asylum last year after 7 years of wait, now he wants to apply for a green card, but he extended his pass in 2022. He's afraid that might hurt his green card.
Okay. Sorry, I don't know. We don't do asylum cases here. That's a very technical asylum question.
Okay. I had my second interview. When do you think I will get a decision? I'm from a partially banned country.
Okay. So it depends on which country, right? And so if it's a full pause, then you won't get an answer. It will just be indefinite pause, right? Because you can't get any benefits. Yeah.
The police sent an arrest decision to my house after I came here with a visa. Is that a good case for asylum?
Oh, okay. So again, we don't do asylum cases here. But from my understanding, after you came to the U.S., now there's persecution back in your home country. You want to use that to make an argument. Sure. It's definitely an evidence to support, but you should definitely consult an asylum attorney.
Can you change your name back at the oath ceremony to your original name?
If you requested a name change on the N400 and after you go through the interview and it's done, then that's done. You cannot change your mind after the N400 interview. Not at least to the best of my knowledge, right? We've tried it in the past. Some clients just change their mind again. We couldn't do it. So to the best of my knowledge, after the N400 is done, they've already closed the case, passed it over to the oath ceremony. Your naturalization certificate is printed. You cannot change your name again unless it's wrong, right? So if the certificate name change is different than what you requested in N400, then it's a clerical error on USCIS. Then you might be able to change it. But other than that, you cannot.
I have my interview coming up.
Okay, let me follow up. You cannot change it at the oath ceremony. You cannot change it with USCIS. You can always go through a name change at the normal courts. It just takes maybe another 6 months. You have to go through that process. But that's the only thing.
I have the interview coming up for AOS. Do I need a lawyer to prepare for that interview?
For the entire time that I've been here at this firm, our policy has been no. You can totally prepare it on your own. We can help you prepare it and then you can go. You don't need an attorney to go with you. Last year, we changed our stance. Now we are saying if it's a medium case or above, we recommend attorney representation at the appearance. So unless it's super clean, squeaky clean, super good, then you could still go alone. Interview prep is always a plus, right? So, you've already filed, you have an interview coming up. You could always do an interview prep. What does it look like? Do a mock interview. Just it's a practice round. That can only help you. It won't harm you.
I'm a Canadian citizen, born in Iran. My dad petitioned for me in 2016. Then 8 years later, 2024, had my interview in Montreal. Been on advanced parole, or been on AP for 20 months. Should I file a writ of mandamus, or is it pointless?
When did he had the interview?
In 2024.
And then
Was on AP for 20 months.
that seems like an extremely long time. However, if it's paused right now, right, and is Iran on the ban list?
But they're a Canadian citizen.
So they are a Canadian citizen. I mean, we have a case that's exactly like that right now. And I remember looking into the National Visa Center.
Yeah, they're in admin processing for 20 months.
Okay. Now, admin processing at the consulate level, you cannot do mandamus to sue them to make it go faster, right? If you're in the U.S. and you did adjustment of status, you can use the mandamus. So I wouldn't recommend a mandamus against the consulate. It's just, there's too much non-reviewability for the consulate so they could defend themselves. Yeah, but I mean, we have the exact same case, but we're doing the adjustment of status.
Any updates regarding the national interest waiver for the banned countries, specifically for doctors?
No, we haven't done any. And I haven't heard of any. I haven't looked really carefully, but I haven't seen that there's like mass approvals or anything like that. My recommendation is if you are in that situation, just do it, right? You don't wait for other people, right? You have a strong claim, just make a filing.
Legally married, but can you mention your wedding in 7 months after your application in your evidence?
Sure. Yep.
Did this grandmother who was out have like a bad reason for absence? This minor, they're trying to get out for 3 years because of medical reasons, and they didn't have control over their travel decisions because they were a minor.
It's a complicated situation. Yesterday, the reason I couldn't do this live yesterday was because I went down to Mexico to help 2 people come in, and both of them have been left the U.S. for over 7 years, not minors. And so we do a lot of these cases, and it wasn't just the 2 of them. A couple of weeks before that, we did another case for somebody who left the U.S. for 4 years, 5 years. Their passport was confiscated. You prepare your case well, you should be able to enter. We didn't represent the 72-year-old grandmother when they flew in by themselves. We did their I-90, 2025 last year. But then once they got the receipt, once they got the fingerprint waived, they decided to try it on their own. And they were successful many of the steps up until they got detained. So I don't know exactly what kind of excuse they were trying to explain to the officer and what led to all this, altercation and detention. I could say they have a really good case, to the best of my knowledge, compared to many of my other clients who has it worse. But in this case, it was Seattle Airport. That officer, that ICE officer, they're just extremely strict. So preparing your case well is one thing. Finding the best port of entry, talking to the best officer, that's like another thing, right?
Oh, so for this AOS interview, they do have an overstay on their visa.
Was it a visa overstay or is it a visa waiver overstay? Because today's news is purely talking about visa waiver overstay, not being able to get bond and being detained by ICE. That is a pain in the butt, right? Now, if it's a visa overstay, you didn't sign this waiver to waive all immigration rights, so maybe you won't be detained by ICE. If your case gets denied, you still might get an NTA, notice of intent to appear, to go to immigration court and to fight deportation, but at least it's not being detained without bail.
And how much do you typically charge to help people prepare for these?
$250 consultation, right? We can help most people in the world with most applications other than like asylum, U visa, T visa, a few other things that we don't do. But almost anything else, including EB1A, all these different things, I'm pretty confident during a consultation session, we can give you so much that you can do so much on your own. But then, of course, afterwards, if you're interested in our service, if we can, and if we have the availability, we could provide a retainer. But the goal of the consultation is not sales. It's to, help you as much as you can and answer all of the questions. And, it's recorded. We send it to you so you can rewatch it,
So even people who came with visas and married to U.S. citizens are not eligible for bond? That's crazy. Should we wait to file our cases until things are getting better?
So this is Visa Waiver. So these are from countries that didn't need to go to the consulate or embassy to get a visa. These are from the core partnering countries, right? So you think Canada, think all of Western Europe practically, think Australia, New Zealand, Singapore, Japan, think partners of the United States. These countries, you don't need a visa, just come in. But now, because you didn't, because you used a visa waiver to come in, you signed this waiver, you waived all immigration rights. So now, if you happen to marry a U.S. citizen, if you happen to apply for adjustment status, somehow you are a second-tier citizen. You are worse than, enemies of the state that cross the border, illegally or whatever, right? Like now we can detain you without bail and hold you for months and months and months.
So which cases are they targeting for pre-terminating asylum cases?
I don't know. Yeah, we don't do asylum cases. Sorry.
How do we apply for a minor passport with an absent father who lives in another country?
The father will have to write a consent, have it notarized through the embassy, sent over to the U.S. Mom, and with the consent form, and the child applies for the passport. That was at least a process that I did back in like 2017, 2018. Pretty sure you still have to do that, but don't quote me on it.
Would a 2-year delay... how do I do an adjustment of status while I have a pending F2B case in the consulate? I live in Canada.
Okay. The hardest part is you have to get a visa to come into the U.S. first, and then you file for adjustment of status. F2B pending and the consulate doesn't matter. You can always apply for adjustment of status. But the key thing is, how are you coming in, right? So if you're in Canada, and if you're Canadian, you need to apply for a visa to come in to do adjustment of status. In the past, some Canadians have just crossed Visa Waiver, and assuming the CBP didn't know any better, then they let you in, and then you apply for adjustment of status. However, because of this case now, we're saying, you came in as a Visa Waiver. You waive all your rights. So if they deny your adjustment of status application, then they detain you and deport you. But that's this complication, right? Just because your case is pending with the consulate doesn't affect your adjustment of status. The only thing it affects is how are you going to get a visa to come in? Because now the consulate will say, well, you have immigrant intent. I don't believe you. I'm not going to give you a visa. Just wait until we finish processing your F2B, and then we'll give you an immigrant visa, right? So that's, I think, the complication.
For immediate relatives to a citizen, can an applicant still use CSBA years after an AOS is denied?
I don't want to say no. I think it's very fact dependent. Maybe it's most likely not, but definitely want to look into it.
So kind of case dependent?
Yeah.
Would a 2-year delay on this consular processing, admin processing at the consulate be considered unreasonable? I think it's a strong mandamus case, don't you think so?
I agree. I fully agree. Do you know how long it takes for an officer to adjudicate one of these cases by their own training manual? Less than 15 minutes. 2 years, 15 minutes. 2 years, 15 minutes. Yeah, it's pretty good argument that they are taking their sweet time, and it's an affront to your civil liberties. However, the courts, the federal judicial system doesn't really have that authority over consular processing. So that's where you're stuck, right? So if this was an adjustment of status in the U.S., I would have said, 2 years, do it.
Do we need to register in selective services system and age of 18?
Yes, you have to register for selective service. But again, fact dependent, specific, right? Depends on what your nationality is and stuff like that.
How do I make sure I'm not detained while my case is pending? Should I not even work with a work permit?
Ooh, that's a tricky one. That is an extremely tricky one. Hot topic. A lot of people are discussing this. How do you make sure you are not detained while you are in the process of doing an adjustment? Should you not even work? That is so hard. There's so many people on a full spectrum. And I can say there's no right answer, right? All the legal professionals that I know, all the people who are in this situation, everybody has a different thing. So don't feel bad about your choice. Make the best one for yourself. Some people need the money. Just work. Some people have the luxury to be able to stay at home and have friends and family support them. Then you're a little bit safer, right? Every situation is different. Every argument is different.
And I believe we said to help prepare people for the interview, it's just a $250 consultation.
Right.
Is that right? Yeah. Can you travel out with an asylum-based green card and your country's passport for a holiday?
So number one, don't go back to your home country. That's what CBP officers get really pissed off about. But yeah, if you already got the green card, then yes, freely travel.
How long is the finance visa taking?
Fiancé visa? I think we're seeing 18 months last I checked, but they change all the time. And they also say, don't trust it. Like the officers themselves say, don't trust that system. So it just takes a long time.
My husband has just completed his interview in Nigeria and was given his 221G. Should I rush the case back to the U.S.? And what will U.S. be asking for under 221G?
So if this individual is able to have an immigrant visa or a non-immigrant visa and able to enter the United States, that's a big if.
Right, because Nigeria is one of the entry bans.
Yeah. So if you are somehow a qualified national interest exception, you're able to get a visa and the CBP officer lets you in, even if they let you in on a parole, right? And that's the success story that I'm going to talk about later. Even if they let you in on a parole, not a visa, which might be your best chance, by the way, right? If a CBP officer lets you in on a parole. If you're able to get in on a parole or a visa, then you might be able to file for an adjustment, right? Because the ban is banning consulates, but not necessarily the U.S. So you might have a shot there. But it's hard. It's just extremely hard.
This is for the AOS after an overstay. Do I need to print my entire application or just what they asked for during the interview?
Wait, what? You already went to the interview? You didn't go to the interview? Do you need to print your application to bring to the interview? They say don't do that. And the reason they say they don't do that is because it's very big identity theft problem. If you bring your entire history and then you go and somebody steals it, that's a big liability. So they say don't. Secretly, I think it's because they want to test you to see if it's real or not. And so if you have the whole thing and you're memorizing and you're looking through it, it's just much harder for them to tell if you are who you say you are. So you do your best judgment, right? They are going to try to ask you questions from your entire form. If it was me, my personality, I would definitely print it and I would be reviewing it. But, that's why, but yeah, they say don't print the whole thing and don't bring it.
Any advice for someone filing parole in place for their wife? I swore an oath for the Air Force.
Great. Every parole in place filing with the service center, it's individually adjudicated and every service center is different. So I highly recommend when you do file it, make an info pass and double check how the filing is going. So I see like certain filings in like Santa Ana office and like the Chino office, the San Bernardino office, they adjudicate it differently. Some people want you to write an affidavit and statement documenting all the entire history. Some don't require it. And because they don't make it explicit, you don't know exactly what they want. And then it gets stuck for like a year. So and the Army or the Air Force who's helping you, or you're helping yourself prepare the whole thing, there's just no information online about what they want specifically. Every service center has their own individual adjudication standards for parole in place. I could assure you of that. So double check with that office. And the only way to do that is to do InfoPass, go in person and ask. Yeah.
If you're waiting for H-1B visa adjustment to green card, are you allowed to travel?
H-1B has a special privilege where you can travel, and when you come back in, it is not considered abandonment, if that's what you're asking. So H-1B is one of the very, very unique visa categories that allows you to do that without having an advanced parole.
S2A priority date is June 2023. I-130 is not approved yet. It became current a few months ago. What is Seek to Acquire for CSPA? How are you going to apply if I-130 is not approved yet?
Has to be approved, then it has to be current, and then you seek to acquire within a year. That's the idea. So all three has to happen. If it's missing one, your age is not locked and it doesn't continue. So you have to get the approval. You have to, prior dates have to be open, and then your age is locked, and then you minus the adjudication time, that's your CSPA age, and then within that window, you must seek to acquire. And if you don't, they consider it abandonment.
Do you think I'll be able to become a citizen if the last time I got in trouble was in 2009?
It depends on what trouble, but the answer is most likely you are, because they focus on the past 5 years. But certain crimes, they do look past the past 5 years.
If I'm in one of the 75 countries on my interview day, do I get the K-1 visa?
So if you haven't gotten the visa yet, you probably won't get the visa, right?
Yeah, feel free to ask any questions you have. I got my real ID in California while I had legal status. DMV recently said I don't have legal status for real ID and it must be canceled and I must return my real ID. What should I do?
It's the first time I've heard of that. That's pretty crazy. I mean, I can only tell you should comply, right? If the state government is telling you to do something, you should probably do it.
Okay, this one was initially in Spanish, so I hope this translation is accurate. My 601A is approved. IR1 is awaiting. CDJ appointment, non-criminal R. I'm about to file a motion to terminate in Texas before leaving for the interview. Case is still admin closed. In your opinion, will they grant the motion to terminate?
I have no idea. I'm sorry.
The translation isn't great. Sorry about that.
Yeah, that's a lot of facts. But yeah, sorry, I don't know.
Can I take my kids to an AOS appointment if no one is there to watch them?
Yes. I've told clients maybe they get, yelled at a little bit, but I've seen people do that and it's been fine.
If you applied for I-130, AOS, including work permit, what follows next after the receipt notification?
Biometrics, interview, approval. Certain cases, interview could be waived, and so after biometrics, then green card just arrives.
Due to a divorce with name change, do I need to update my naturalization certificate?
Yeah. No. What? Wait. Do you need to update your naturalization certificate? So, no, you never need to update your naturalization certificate. You just change your name, and once you're done changing your name, then that's done.
Do you think the lawsuit filed in early Feb against the Department of State by civil rights organizations can temporarily lift the 75-country ban?
No.
Thank you. So this is about the K-1 from Somalia, or Somaliland.
Mm-hmm.
He say you will get the K-1 Fiancé visa. Do you think you will get the K-1 visa?
I mean, a lot of K-1s get approved, so do a really good job.
But from one of the banned countries?
Sorry. Not, I'm very suspicious. I, I would place my bet that the consuls will not approve the K1 visa.
And 400, 10-month residence break. Applied 5 years and 8 months later. No travel during that statutory period. Any concern?
Can you say the whole thing again?
Yeah. And 400, there was a 10-month residency break, and then they waited 5 years and 8 months without doing any travel. Any issues?
Oh, yeah. Yeah, that's fine. You already passed the 4-year 1-day rule. So I haven't seen any denials on naturalization when it's past the 5 years. So they always say do the 4-year 1-day rule, apply again later, and so you've already waited that long. I've seen some cases that get approved without waiting the 5 years, right? You apply like next month, and you argue that 10 months was out of your control, right? And lots of cases still have gotten approved. So I think you are in a good spot.
Okay, I want to finish up talking about the news.
We don't know if this visa waiver ICE detention situation is going to spread throughout the country. Even though that's what the court ruled, even though that is a basis, that is still just one circuit of the entire United States. Maybe not other officers would get that far. And again, it is after the 45 denial. And so we still have a lot to watch, but it is extremely concerning and everybody is watching it. And the more I find out, I will definitely share more. But it is the first instance where we see something like this happen. And if it does become more and more common, then it becomes the end of everybody who is from a visa waiver country. If they want to get immigration status, they want to get a green card, it all has to be done at the consulates. It can no longer be done in the U.S. And that's the very ironic thing where you give the country the visa waiver privilege, but now you prevent all of them from having that more convenient right of doing adjustment status in the United States. Is that the intended effect of what they're trying to do? I don't believe so. I believe just the current immigration climate is just saying we want to, strictly enforce the rules. We want to deny as many people. We want to detain as many people. We want to deport as many people. And so now, because of that overall circumstance, it's causing our friends from all around the world to have to suffer. Is that a good thing for the United States? I don't believe that's what people have in mind when they voted for stricter immigration enforcement. I don't believe that's saying, oh, somebody from Ireland, well, we should detain them, and even though they have a marriage to a U.S. citizen, right? So I think the public needs to know about this. I think Congress, I think immigration courts, and I think USCIS need to really think through this public policy. Let's make America great and not suck. This sucks. Sorry.
Okay.
All right.
We'll answer a few more questions and then jump into the success story. So when do you think this immigration pause will be lifted?
I think it's going to be more than 3 years.
Will a summons for illegal taxi at the airport affect my case?
Well, what?
A summon for illegal taxi at the airport.
Oh,
my case.
You have to look into the state rules. If it's just like a citation, if it's like a traffic offense, maybe it's okay. If it's a misdemeanor, it's a different story. Hopefully that's not a felony.
My N400 was denied, and 336 was denied too from 2015. Can I still apply for citizenship now?
Yes, but let's look into why it was denied, because it's much stricter now. Worst case scenario, they deny the N400 again, and you go into immigration proceedings, into deportation proceedings, and they cancel your green card, right? 2015 was a very different administration, very different time. Maybe whatever was the problem back then has already been solved, and you qualify and you can file. For example, maybe in 2015, you just left the U.S. for too long and you didn't meet the physical presence. That's not a problem. You should totally apply again. If it was for a drug offense back then, it's a much more serious offense now.
How long before I am ready for adjustment of status should I request FOIA? TIA.
I just say people should just do it. I'm a documenter. I have like 3 journals and, a whole planner every single year. I like to document things. So if I were you, I would just do a FOIA right now. Just get your entire documents. Unless you're saying you want to wait until they adjudicate, and then after approval or denial, then you do the FOIA so you can see what they say. Well, then sure, wait. But that won't help you with the case, right? And so if you want to potentially help you with the case, they do say FOIA takes 20 days, even though realistically sometimes it takes like 9 months. So I would just say do the FOIA. And if you're really curious, do a FOIA again afterwards, right?
Is refugee subject to public charge?
Great question. I looked into the public charge rules a few months ago. I believe refugees are still an exception, but don't quote me on that. I don't have the law in front of me. I would double check. But I remember in the back of my mind, reading through it, refugees were immune from public charge. Now, with that being said, I could tell you the new public charge rule hasn't been implemented to the best of my knowledge. I have not seen any cases get denied or challenged because of the new public charge rule in the United States, right? So rule went into effect August. Everybody applied September, October, November, December, January. People who went to the interviews. I haven't seen any request for evidence or denial because of public charge. So.
Okay, so this is for the AOS interview that's coming up. I had an RFE. Do I need to bring updated income since it was for income purposes?
Yeah. I mean, if you had an RFE, then you prepare everything, you should have sent it back in. And after you send it back in, you got another interview. You should definitely update that even more and go in and be able to explain yourself.
Can having used Medicare or having Medicare in the past, never used but repaid back, negatively affect an F1 AOS?
Yes.
I am a Canadian citizen born in Iran, working in the U.S. on a TN visa. Can I renew my TN, or is that also on pause?
I don't know.
I mean, Canadian citizen, I think dual nationals are exempt from all the pauses, right? That's what I was seeing.
That is what I've seen too. But I'm just trying to think, is that exception applying to the immigrant visa? And TN is not a non-immigrant visa, so it should be fine. But is it the 19th country where all benefits are paused? If all benefits are paused, the TN visa is one of them.
But even, I think dual nationals are also exempt from that, right? As long as you have the Canadian passport.
That's true. I have to go back and look at that ruling, right? Because I remember that ruling was from the Department of State website, but I don't have a photographic memory, so I don't remember if that applies to non-immigrant visas as well, and also dual nationals. Yeah, I distinctly remember it's for immigrant visas, dual national exemption for immigrant visas. I don't remember if it's for non-immigrant visas as well.
If I have a theft offense under 200 and a diversion program in Florida, will that affect AOS?
Let's say that again.
Theft offense under 200, did diversion program in Florida 2 years ago.
Okay.
Will that affect AOS?
Affect as in, will you have to change the way you fill out the form? Will the officer ask you? The answer is yes. You will have to give an account. Is that by itself an inadmissibility that causes you to be denied? Maybe not. So you would have to do a good moral character analysis. You would have to argue and do your best to kind of explain. From what you told me, I don't think it is. But again, I am not an attorney in Florida, so I cannot give legal advice regarding Florida law. So that's something that you could take your offense, plug into ChatGPT and see if this is an inadmissibility. If the answer is no, it is not an inadmissibility, which is my opinion, you should still be able to get your green card. But you still have to give an account and explain and do your best to prove you deserve the green card, right?
Okay, thank you for providing the English translation. So 601A, approved. IR1, interview pending in my country. No criminal record. EOIR, Texas case, has been admin closed. I'm filing a motion to terminate before my travel to the interview. Do you think a judge will grant that? Motion to terminate this admin closed case.
Walk me through everything one more time.
Yeah. 601A approved.
Yeah.
IR interview pending.
Okay.
No criminal record.
Interview pending. Okay. Interview pending.
Yeah.
Okay.
I have an EOIR case in Texas that's been admin closed.
Okay.
And I'm filing a motion to terminate before I travel for my interview.
Will they terminate it?
Yes.
I don't think they will do it within 2 to 3 months because of the backlog. But you should keep on pressing and keep on pressing and keep on pressing them. It is not the state's position to want to reopen closed cases to terminate. It takes up a slot. It takes work. They're completely understaffed, overworked. So they will not likely heed your urgency.
Okay, I want to jump into our success story.
Oh, yeah. All right. This is a good one, guys. All right. This sheet of paper right here is the approval where the immigration judge approved our motion to close the case. Even though the State Department tried to oppose it twice, all right? So the respondent, us, right, we filed a motion to terminate the proceeding. And after considering the facts and circumstances, the immigration court orders that the motion terminate is granted. And the reason is because of what we said to the Department of Homeland Security response. Now, I want to go through exactly what we filed and what they filed so you guys could kind of see. We don't do a lot of these, but we were forced to because it was, unexpected. Essentially, last year in September, we filed an adjustment of status, right? It's based on a 245I case. It's kind of complicated. We filed it. What we didn't expect was after the adjustment of status was filed, USCIS transfers the case over to immigration court before terminating it. So normally you deny the case and you give an NTA and you transfer. This happened simultaneously. So that's bizarre, number one. And then, number two, when USCIS administratively closed the case saying, sorry, you were paroled in and you got an NTA, notice of intent to appear, and therefore we cannot adjudicate your adjustment of status. We don't have the jurisdiction. We're transferring it over to immigration court. So that's bizarre, number two, right? The client came in, was paroled in, got married to a U.S. citizen. We filed an adjustment of status. In years past, boom, approval, green card. Now USCIS is saying, sorry, it's not our call. It's not within our jurisdiction. ICE and Department of Homeland Security is taking over, and you have to go through immigration court. Okay, weird. We filed a motion. Please close this case. Immigration court, immigration judge, please terminate this proceeding. Why? Because our client was paroled in, got married to a U.S. citizen, and filed an adjustment of status. It qualifies under 245A. Please close it. And then we'll redo it with USCIS. Then the Department of Homeland Security says, nope. And I want to briefly read what they wrote because it was extremely annoying. All right. So this is the chief counsel for the assistant chief. This is the assistant chief counsel for U.S. Department of Homeland Security, and they filed a response to our motion. And this is what they said. The U.S. Department of Homeland Security opposes the respondent's renewed motion to terminate for the following reason. It is well established that parole is not considered an admission into the United States for adjustment purposes. And they go on and talk about it. Here, the respondent was not admitted or paroled after inspection by an immigration officer at the time of her entry into the United States. And while we granted the parole and released her into custody, the grant of parole terminated when she was served with a notice of intent to appear, and therefore she cannot adjust status. At this time, the respondent has not met her burden to prove that she is not inadmissible as charged and that she is prima facie eligible for 245A adjustment of status because she was not paroled, right? So basically, they were just saying, sorry, if you're paroled, you cannot adjust. It cited all these laws and case laws. I want to share with you how we fought that. Man, I love this brief. And it is not always that I spend this much time fighting it, but this one was a doozy. All right. The respondent respectfully opposes this motion to terminate. In their opposition, the Department of Homeland Security opposes the termination because the I-130 is still pending, the adjudication with USCIS and not yet approved. Oh wait, is this the first motion? Oh yeah, sorry. That was the first motion. Hands, where'd it go? Oh, it was right on top. Okay, there's the first page. All right. Okay, this is what we said. The U.S. Department of Homeland Security opposition to respondent's motion to terminate should be denied because it is premised on a fundamental misreading of 245A. The respondent was released from the U.S. Customs Enforcement and was lawfully paroled into the United States. See all these exhibits. She subsequently became the immediate relative of a U.S. citizen through marriage and filed a properly supported application for adjustment of status. The Department of Homeland Security argues that the parole does not constitute an admission for adjustment purposes. However, respondent does not claim admission. We don't need admission. Under 245A, it expressly provides two independent bases for eligibility, being inspected or admitted, or inspected and paroled. Congress deliberately included parole as an alternative basis for adjustment eligibility. And so this squarely satisfies the requirement for 245A. The Department of Homeland Security further contends that the respondent parole was terminated, quote unquote, upon issuance of the NTA. However, on the same day the NTA was issued, the Department of Homeland Security also issued her a call-in letter directing respondent to appear in a future appointment to be issued a new parole. So the issuance of these additional documents of parole was not treated as extinguished. Rather, Department of Homeland Security affirmatively recognized respondent's parole status and anticipation and continuation of her parole status. And even assuming the parole was quote-unquote terminated, the Department of Homeland Security failed to acknowledge that 245A does not require parole on the ongoing at the time of filing. And so we further argue with additional things, and we even prepared a new 45 adjustment of status to submit to the court and said, you know what? Even if you're right, officer, even if you're right, immigration judge, that parole was canceled and USCIS has the right to transfer the case over to immigration court, we respectfully request that you just approve the green card here and now because the law is on our side. Now, we didn't have to go that far because the court just said, we agree with you, terminated this case, and now we're going to go back to USCIS to reopen the case, and hopefully USCIS accepts it and approves the green card. In this day and age, in this era, where USCIS is just kind of shifting their troubled cases over to immigration court, and immigration court is just detaining people, and ICE is detaining people and not allowing bond, the one solution that you can do and you must do is to terminate the proceedings. Terminate the immigration proceedings. Terminate the deportation proceedings. Close it out. And then transfer it back to USCIS to get approved. And that's plan A. Plan B is to force the immigration judge, based on the rights and privileges and responsibilities granted to them, to then adjudicate the case as if they're a USCIS officer and then approve the green card. So give us heaven or at least send us back and we will fight it again. And don't let ICE, don't let them detain the client and refuse bond, because that's what they're doing. They're doing it to green card holders who are entering the country. They're like the 70-year-old grandma from last week. They're doing it to visa waiver people who are, marrying U.S. citizens. And so it's a crazy time in immigration where different agencies are just passing the buck back and forth. When the government makes an argument, double check their argument. Maybe they ChatGPT'd it and they hallucinated. Maybe it's not correct. Fight them every way. And there are still good immigration judges, such as this one, who approved the termination, the case is closed, and now the client still has a chance to get the green card back with USCIS. Extremely proud of the team that worked heavily on this case. Gabby, Giselle, and this was Giselle's first case, and I like doing that, right? Difficult, complex cases. Well, who better to do it than you, right? And that was the training I got in law school. The first case that you ever work on, you prepare really well and you make your oral arguments in mock trial and you're doing the competition. I remember the judges who said this: don't forget this zeal. Don't forget this first time you're working on this case in your first oral argument, because the effort, the intellect, the passion that you put into this case, where as if your life depended on it, in the real profession, people lose that drive. People lose that focus. People lose that passion. And work gets sloppy. And so what the judges have witnessed at the moot court trials, they said a lot of times this actually might be your peak. And after you graduate, after you pass the bar, suddenly you're not working on one case, you're working on 100 cases, you're spread out, and you forget that passion, forget that zeal, forget that intellect, and you forget what it takes to do a good case. And so sometimes some of the best cases are done by first-timers because everything depends on it. And this is a good example where she worked on it, we worked on it. I usually don't do these type of cases, but this was our client who filed a 45 and we had to do it. And we won. And so these are still possible. And again, also I want to shout out Arthur, who was shadowing us the entire time, helping us work on this case. I want to shout out Emily. I want to shout out Megan. I want to shout out Nicholas. I want to shout out all the attorneys who kind of came together, who really helped and to strategize, because we had to win at all costs. I was just not willing to concede such a stupid thing, right? Was the client paroled or not paroled? You paroled her like multiple times, and then now you're saying the parole is not a parole. That's a very dumb argument. And the immigration judge agrees, and we won this. So very happy, very glad to share the success story. Wish everybody a great weekend. And I think we're out of time, right? So thank you guys. Take care. See you next week. Bye-bye.